Good afternoon and welcome to another cost seminar from King's Chambers. It still feels novel and exciting to be doing these by video. I was talking to a solicitor about her first experience of a virtual trial, which seems a very long time ago now. And she told me she thought it was going to go quite well. She'd had a word with the client, briefed him on what to expect, made sure he knew how to turn on his mobile phone and get onto the hearing. And so when she logged on at 5 to 10, she wasn't expecting the sight that then before her eyes, where she saw him sitting on his sofa, wearing only his underpants and munching his way through a family bag of crisps. The court clerk came on and simply stared and stared and stared before quietly announcing she was going to bring the judge in, after which matters went rapidly south. Now, I'm afraid we can't see you. So for all I know, you're sitting at home in your underpants, making your way through a giant bag of Monster Munch. But what we're going to do now is sort of take you through qualified one-way cost shifting and the latest decision of the Supreme Court, Hoe and Adelican. In terms of a division of labour, I'm going to set the scene, then I'm going to pass the baton over to Erica, and we're going to have a chat about the practical consequences of Hoe and Adelican, so that you can sort of start to think about how it's going to unfold in your practices. One of the pleasures of growing old is that if you wait long enough, you'll see all the points that started to vex you during your youth coming round again. And so it is with qualified one-way cost shifting. I started practice in the 1990s when there was still legal aid available. And legal aid and the scheme that operated then was the origins of the current system of qualified one-way cost shifting. In essence, if a claimant or plaintiff, as it was at that time, lost a case at trial, then they benefited from cost protection contained in the Legal Aid Act, so that an order for costs could not be enforced against them, save in very limited circumstances, and usually dependent upon what their financial position was. Along the way to trial, often a plaintiff would take a battering from interlocutory cost orders being made against them. But in those circumstances, the judges used to make what we called Lockley orders, whereby the defendant's costs would be set off against the costs and damages payable to the plaintiff. And so it went on until, of course, the government effectively abolished legal aid for personal injury cases, at least from 1999 onwards. What they replaced it with was the Access to Justice Act of that year, with its scheme of additional liabilities and recoverable success fees and AT insurance. So legal aid started to fade out of the picture, though of course there was a lag. Of course, in a with regard to joined up decision making, there was an immediate problem. Whereas the net cost of legal aid had been about £30 million for the government each year, straight away the costs of additional liabilities, principally through the NHS payments of costs for clinical negligence cases, immediately started to roll in at many times that. And ultimately, of course, it came to be seen that the Access to Justice scheme was simply too expensive as a system underpinning compensation in this country for personal injury and clinical negligence claims. So what we then had, of course, was the Jackson reforms. And it's worth noting that if you go back to the Jackson report and his third implementation lecture, his vision of qualified one-way cost shifting was very different from that which was ultimately enacted in the civil procedure rules. What he thought was that the scheme should be effectively means tested. You'd take into account the financial circumstances of a claimant in determining whether they should have to pay costs. That, of course, was not the scheme as ultimately enacted. And what we now have is Section 2 of Part 44 of the Civil Procedure Rules. It's worth considering this because these provisions, which are very few in number, really 4 substantive rules, plus a 5th rule, which I'll come to in a moment, effectively underpin the entire system of compensation or adjudicating upon compensation in this country, or in England and Wales, I should say. 44.13 sets out the scope that qualified one-way cost shifting applies to claims effectively for personal injury or for Fatal Accidents Act damages. And to that extent, QOCS remains an anomaly within the rules, because although there was talk a decade ago of extending QOCS to defamation and privacy, or disability discrimination, or judicial review, or other categories of cases, that to date certainly hasn't happened. And it raises an interesting point, which we'll consider when we look at the practical consequences, namely to what extent detailed assessment, for example, can be said to be proceedings for personal injury. 44.14 is the core rule, because it provides that in essence, you can only enforce your right to costs as a defendant from any cost orders made in your favour up to the aggregate of any orders for damages or interest made in the claimant's favour. And what Hoe and Adelican is really about, as we'll see, relates to the construction of that rule. 44.15 disapplies QOCS where a claim has been struck out, and 44.16 deals with circumstances where QOCS might be disapplied for reasons such as fundamental dishonesty, because there's a mixed claim, or where there's a claim made for the financial benefit of somebody other than the nominal claimant. So those are the core rules, and just before them in the wording of the civil procedure rules is 44.12, which is the power of the court to direct a set-off of claimants' costs against defendants' costs. And it was the interrelationship with that rule with 44.14 which came to the fore in the recent case. An interlude, however. Before we get to Hoe and Adelican, it's worth noting that there are a number of cases along the way which in effect were precursor, or indeed the essential foundations of what the Supreme Court ultimately did. The first of those was the aftermath of the decision in Hoe and the Motor Insurers Bureau in the Court of Appeal, where the Court of Appeal had to consider whether 44.14 and 44.12 in effect operated in parallel, or whether in fact 44.14 trumped 44.12, so that you had a ceiling, if you like, upon the costs that could be enforced against a claimant, really only up to the aggregate of damages and interest. And in Hoe, Lord Justice Lewison had no difficulty in saying, well, actually, set-off and enforcement are two quite different concepts. So there's no difficulty with ordering a set-off of costs against costs in a personal injury claim. And that approach had, of course, a long pedigree, because it was exactly the approach which applied under the Legal Aid Act. The next significant case, before we get to Hoe, was that of Cartwright and Venduct. And Cartwright and Venduct went to the Court of Appeal on a couple of issues. The first was, in effect, what are the proceedings for the purposes of 44.13? And the Court of Appeal had little difficulty in deciding that that related to the proceedings against all defendants collectively, as opposed to separate proceedings in one action. And secondly, what was the construction to be given to 44.14? And in particular, the narrow point in Cartwright and Venduct was that, in essence, orders for damages and interest meant simply that. A Tomlin order, which has a curial part, court order, and a schedule, which has nothing to do with the court order, is not an order for damages. And on that basis, because there was no order for damages in the claimant's favour on that construction of 44.14, it was not possible to enforce the claim for the defendant's costs against the claimant. And because it was a multiple defendant case, there was no possibility of set off under 44.12 either. Cartwright and Venduct, however, in effect contained a time bomb, which I've been waiting 3 years for it to detonate, which related to the consequence of Lord Justice Coulson's comments on the application of 44.14 to Part 36 settlements. I mean, his view was that 44.14 has no application to a case that settles under Part 36, as much as it has no application to a case that settles on a Tomlin order. And the consequence of that was really quite profound, because it meant that any settlement of a claimant's damages, however you did it, was not an order for damages and interest. And in those circumstances, a defendant's right to or ability to recover their costs was grounded on 44.12 and the Hoe and Motor Insurers Bureau principle. And so matters rested there. And now we come on to the decision in Hoe and Adelican. Hoe and Adelican can be seen as a tragedy in 3 parts. It had 2 trips to the Court of Appeal and 1 to the Supreme Court. In the first trip to the Court of Appeal, the issue really there was whether standard basis costs and fixed costs were what the parties had actually agreed. Had they agreed that standard basis costs precluded the application of fixed costs, or did it mean that the court could look at the matter more holistically to determine whether the claimant's case was limited to fixed costs? And because the order had this ambiguity in it, there was an outing to a deputy district judge who effectively decided that fixed costs would apply, but the claimant could, of course, pursue an application for exceptional circumstances costs under Rule 45.29J, a decision which was promptly reversed by the circuit judge, His Honour Judge Woolwick, and then reversed again in the Court of Appeal in the defendant's favour. However, matters came back to the Court of Appeal to argue, in effect, the point that had been left hanging, or foreshadowed at least, by Cartwright and Venduct, namely whether Rule 44.14 effectively ousted Rule 44.12, so that, in effect, the only scope for set-off for a defendant's costs was against an order for damages and interest. And the Court of Appeal decided that there were very good grounds to argue that that was in fact the case, although they decided that they were bound by Hoe and the Motor Insurers Bureau, and the very narrow circumstances in which the Court of Appeal would depart from a decision of its own wasn't made out. But the matter then went to the Supreme Court. And if you look at the judgment, it's extremely short. It's the substantive decision of Lord Briggs. He makes the point early on in the judgment that the Supreme Court doesn't really want to decide this sort of point, noting that there have been 2 divisions of the Court of Appeal who have taken 2 differing views. And it's really a matter for the Civil Procedure Rules Committee to look at. Nonetheless, the Supreme Court is seized on it. And the effect of the decision of Lord Briggs and the Supreme Court is this. In essence, 44.12 is effectively ousted by 44.14 in this sense, that if there's an order for damages and interest made in a claimant's favour, then that provides a ceiling or headroom against which a set-off of the defendant's costs can take place up to the limit of that headroom. But it doesn't go further than that. And whereas you might the Supreme Court judgment have had a situation where the set-off could bite far more deeply into a claimant's costs, that you can no longer do after the Supreme Court decision. People have said to me already, Andrew, do you think the Supreme Court decision is right? And I say to them, well, it doesn't matter what I think, it's the Supreme Court. And you're stuck with that unless and until the Supreme Court reverses itself, or more likely, there's a rule change from the Civil Procedure Rules Committee. And it may be that this is a matter which is going to be addressed. But let's face it, it's been 3 years now, coming up to 4 years, in fact, since the decision in Cartwright and Venduct, when an invitation was given to the Rules Committee to look at QOCS, which doesn't seem to have been taken up in any shape or form. And so it may well be that the Supreme Court's decision is going to gain traction and apply for a good number of months, if not years yet. And the consequences, I think, for personal injury litigation are going to be extremely profound. So I've taken 15 minutes of this session in giving you a very a quick overview of QOCS, the story so far, and putting the Hoe and Adelican decision in context. We're now going to move over to what we think the practical consequences of this decision should be. And this is where we need a bit of audience participation. According to the little gizmo at the bottom of the screen, we've got 469 of you online at the current time. You have got a chat facility and a Q&A. What we would like is some questions from you as we go along, and we're going to try and weave a response into the points that you raise and deal with them as seems a fairly logical way to proceed. But I'm now going to pass the baton over to Erica, who'll give you some thoughts upon the way that things might unfold.
Yes, thank you, Andrew. I hope you'll forgive me. I don't have a fancy background like Andrew's. I said this at the outset when we first came on the line. I'm very jealous. I think it's lovely. But going back to the Hoe and Adelican point. So having discussed this with Andrew, we had a deep discussion about it over the weeks, as one could imagine. We think that there are 4 particular areas of practical application that parties can start thinking about in terms of where to go from here, because the initial and immediate effect is going to be felt by parties across the divide. Claimants, I suspect, are going to be celebrating, and defendants, I suspect, are going to be commiserating. Because it does appear now that there are limited options for defendants to try and recover costs by whatever mechanism they think appropriate, but they are limited whichever way one tries to cut it up. Because of course the effect of Hoe is such that it does limit that available pot against which a defendant can enforce to the aggregate of damages and interest. But the enforcement which one can go against will only go up to the ceiling of that damages and interest, though the defendant can look at a number of different enforcement mechanisms by which to get that clawback back. And we're going to come back to the practical application of that momentarily. But in my view, one can arguably say that, is this the correct position for parties to properly find themselves in such a case that it properly reflects the intention of the Jackson reforms and the implementation of QOCS in the first place? Now, arguably the answer to that is yes, but equally, sitting entirely on the fence, one can see that there would be a significant injustice that could be said to be created if the purpose of QOCS could be said to be defeated by allowing recovery of costs against costs, and thus expanding that pot larger than that which is just the claimant, or the aggregate of the claimant's damages and interest. But that said, nonetheless, there are options that defendants can still look at, and consequently there are still areas that claimants need to be aware of and look to potentially defend themselves in line of potential avenues that defendants can take. The first one that I want to talk to you about is the Cartwright point that Andrew beautifully set out as being the time bomb that he's waited to arrive for the past 3 years. Because of course, Cartwright, the point there being that damages recovered further to settlements are not orders of the court by which a defendant can enforce against. Now, The reference to which Andrew referred, the decision of Lord Justice Coulson, can be found at paragraph 45, where he threw the grenade into the mix. And what he said there was that it made no difference if there was an acceptance by way of Part 36 offer. But of course, what Cartwright expressly dealt with was Tomlin orders. It wasn't Part 36 offers at all. And as Mr. Hogan and Andrew will properly tell you, whether a Part 36 acceptance was an order of the court or not was not expressly argued at all in Cartwright. And one can see from the judgment quite readily that it's simply not there. So that is arguably, substantively, obiter dicta, such that any argument of the court in claims moving forward can easily be distinguished on that point. But practically, when you look at this, if we look and go through the practical effect of this, we know that once a Part 36 offer is accepted, what happens expressly is that the claims stayed. That's what happens. And it's right that if one looks through the totality of Part 36, that there's no recording in terms of a court order that's generated through the acceptance of a Part 36 offer. But what there is, and furthermore, what there is, of course, is there is specific provision within Part 44.9 for a Part 36 offer acceptance to be the creation of a deemed costs order, which would be logical in the event that one accepts that a general Part 36 acceptance doesn't create an order of the court, because of course one can't proceed with detailed assessment proceedings absent a costs order. So hence why 44.9 needs to bring in that express reference to a Part 36 offer creating that deemed costs order. So putting all of those together, one can see that there would be a powerful argument against Part 36 offers acceptances not being in and of themselves the creation of a court order. But query whether in any event that would be necessary at all because of the effect of 36.14. Now, just to give a recap, of course, Part 36.14 deals with the other effects of the acceptance of Part 36 offer. And what specifically is drawn to mind is subsection 7, which provides that the payment of an agreed sum, that being the settlement sum, if it's not made within 14 days, then the claimant can enter judgment for the unpaid sum. So if you think through that practically, what could a defendant do if it has an interlocutory costs order that it wants to try and recoup in the face of a settlement to Part 36 acceptance? Well, it seems possible that there is an argument that a defendant could simply not pay up within the 14 days, force the claimant to make an application for judgment. And then, of course, once judgment is entered, there is an order of the court then by which the defendant could seek to enforce its costs. And that, of course, then would create the order which is necessary for the application of the QOCS regime. However, it is proper to say that there is a clear and obvious problem with this route, in that the defendant would undoubtedly become liable for the costs of that application, and consequently one does need to work out whether the candle is worth the wick and whether the costs of that application would largely extinguish any benefit that would be gained from gaining the interlocutory cost order that's in the defendant's favour in any event. That's the first issue, of course, that needs to be considered. And then the second issue would be whether the client would be happy with a judgment being entered against them in any event. So query, particularly in road traffic accidents, whether that would be something which would be overall beneficial to the defendant. So whilst this does appear to be an avenue that is possible, there are practical consequences and difficulties that are created nonetheless by trying to go down that route. I'm just noting, Andrew, we have people at the bottom. There are 8 in the chat and 5 in the Q&A. Should we see what they're saying?
Yes, Erica, I think that's good. And do we want to start answering these questions? Because they're now starting to arrive in quite a lot of volume.
And there are a further 3 practical effects that we want to talk it may be if we answer these, they're probably more likely to engage with what we're talking about at the moment. I'm going to ignore Stephen Averill comment about my Art Deco background. I live in an old house. This is what suits it. So let's take them in order, shall we?
Surely.
There we go. Paul Wainwright said what we've just discussed. We've dealt with the late payment point by making an application for interim payment and asking the judgment. Yeah, that makes sense. What does John Pennington have to say? If Cartwright was the intention of QOCS in that costs could only be enforced against damages, isn't there a clear conflict with Part 3620, which specifically relates to late acceptance of Part 36 offers and entitlement to costs, does not say cannot be enforced and relates solely to PI matters? Well, let's unpack that, shall we? That's quite a long question. Cartwright was the intention. What do you think about this, Andrew? Cartwright was the intention of QOCS.
Yeah, I think Cartwright is really about the construction of 44.14 as to what's an order for damages and interest. So the way things are at the moment, there's no problem with an order for costs being made in the defendant's favour. The problem is that it can't be enforced, so it remains as a notional liability. So I don't see a problem or conflict with Part 36 at all. I think Part 36 will deal with contra costs orders going back and forth, but it won't affect, but it's not concerned with the enforceability of them. Because in Hoe and Adelican, in the Lord Briggs said that actually set off is a species of enforcement, a clear conflict of opinion with Lord Justice Lewison in the Howe and MIB case. You have this situation whereby a claimant can rack up huge costs liabilities against them, but which are meaningless at the end of the day if there's no order for damages within the meaning of Rule 44.14. And I think that leads on to a wider point, which is that of claimant behaviour. The way that you can look at it is that the game is on, because in effect, unless you're in one of the very small number of cases which go to trial, interlocutory costs orders made in a defendant's favour are going to be effectively meaningless. Equally, to my mind, the effect of this decision, and perhaps moving on to one of the other questions which were asked by someone who describes himself as a Luddite, is that Part 36 is largely neutered. Because if you think about the effect of a Part 36 offer, it bites in two ways. The first is that it limits the claimant's costs up to a given point in time. The second is it would normally provide that the claimant do pay the defendant's costs after a given point in time. But the consequence of a case settling without an order for damages and interest is that the second part of that equation is gone effectively, because you can limit the claimant's costs, but you can't get them to pay your costs unless you're in the situation where there's been an order for damages and interest effectively at trial.
Yes, thank you. And I'm just looking through these other questions, see whether we can group them together.
Yeah. There's another point being raised by one of the audience, which deals with the situation where if you have a damages claim that settles without the need to issue proceedings, and there are only Part 8 cost proceedings, can you argue that the Part 8 cost proceedings, and I suppose the detailed assessment thereafter, are not proceedings to which QOCS applies? And that raises a very interesting point.
Yeah, absolutely, because of course one has to question then if it's solely Part 8 proceedings, and this is a matter we were going to come on to afterwards, discussing the effect of QOCS within detailed assessment proceedings, because when one goes through Hoe, there are references at paragraph 6 and at paragraph 7 which directly refers to detailed assessment proceedings. But of course the question that's being thrown up is the effect when it's a Part 8 claim, when there's arguably going to be no reference at all to any effort of any element, forgive me, of personal injury. So in those cases, can one specifically and properly say that 44.13 is simply not engaged at all on the strict understanding of the rules, because the threshold test, or part of the threshold test, has to be the existence of a personal injury element. And in cost Part 8 proceedings, one simply doesn't have that. So it seems that there is an argument, certainly to my mind, Andrew, that would be a strong argument to say that QOCS simply doesn't apply in those circumstances.
Yeah. I think that there are two points which flow from that, Erica, and I think you're right. The first point is that if people are going to argue these points, then I anticipate that copies of Cross on the doctrine of precedent are going to fly off the shelves as people look to see to what extent Hoe and its comments are actually binding, and to what extent they're obiter dicta. But the second point is the real point, which is, what are the proceedings? How do you define proceedings? And you'd go to cases such as Plevin in the Supreme Court and look at the elastic definition that proceedings can have. Because we know that technically detailed assessment proceedings are separate proceedings. So are they caught by the 44.14 problem? The anterior point is, well, if there are no substantive proceedings for personal injury, but only a Part 8 claim for costs, does it actually work the other way, so that you don't have a 44.14 track? But that then leads the question that you can have proceedings even where there is no claim form issued. So how wide can you stretch the definition of section 44.13, a claim which includes a claim for damages for personal injury? And I think you're then starting to move away from what I'd say are issues of principle and construction into sort of policy-driven interpretations. And this is where it's going to get really interesting and really sticky as these matters are thrashed out in satellite litigation.
I think that's right, but I think the point on the costs one comes back, and there's a point raised by Paul Wainwright that I'm just trying to find, and he references, of course, the very old case of Myatt 2, which I'm sure you'll remember, Andrew, in respect of whether the proceedings were brought for the benefit of the solicitors rather than for the benefit of the claimant when one's looking at cost proceedings.
That raises an interesting point, because it arises in virtually every case where the damages are £10,000 and the claimant's costs are £100,000. But the starting point is always, of course, that costs belong to the client. So it's the claimant's money, which he's seeking to recover. Myatt involved fairly extreme facts because, of course, in that situation, the conditional fee agreements had been found to be unenforceable. And so to that extent, the claimants had very limited skin in the game in terms of what their interest was. And the interest was predominantly that of the solicitors. An interesting point, I think, is... Sorry?
It's a CFA light as well, wasn't it? So that they truly didn't have any skin in the game at all.
I can't remember the detail, Erica, because your memory's better than mine on points like that. But the other side of the coin to the non-party costs at a jurisdiction is this issue as to whether wasted costs are going to be pursued as an alternative. Because there may be, if you're going to go down that route of pursuing solicitors, then you've got a different set of arguments and considerations altogether.
Absolutely, and I don't know about you, Andrew, but this is certainly something that's been, I've noticed a sharp rise in terms of being asked to advise on wasted cost applications against solicitors in the last couple of months. Query whether that is directly on the back of Hoe, or whether it's just one of those coincidental arguments that are now doing the rounds. But this is certainly an area that I've seen a significant interest in for defendants in the event that they find what they perceive to be misconduct points on the basis of claimants. But going and looking at that, one of course ends up in a situation where they're very tricky orders to obtain, in my experience, certainly. There is a high test, of course, which is the well-trodden path from Rydal and Horsfield back from the early 1990s, I think that was. And the requirement, of course, was that there had to be an improper, unreasonable or negligent act on the part of the solicitors. And importantly, there was that causative element that has to be there. So it's not simply the case that a defendant would be entitled to its costs in totality. There has to be a cutting down to be limited solely to the effect of the causative element from the conduct which has caused the cost to be wasted. So query in those instances whether it would actually, the conduct itself would be sufficient to get one home to the extent of the costs order that one would be looking at, and whether one would even get over the comparative element in the event that the claimant had recovered damages and interest in order to create that aggregate pot. But certainly in instances where there's been an absolute failure of a claim, it would create a pot, or there would be a pot present to a certain degree, where defendant firms could look to try and recoup their costs back. But still, it's still a difficult, fraught area, and it's not an area certainly that is an easy one for defendants to follow.
No. And of course, there raises the issue then, doesn't there, of non-party costs applications against ATE insurers. I mean, what are your views on that, Erica?
They're difficult orders again to obtain. In my experience, they're even more difficult in order than one is trying to obtain against as a wasted costs order against the claimants. But practically, again, I think one looking at that, it's even if one starts bringing these applications, what one's going to end up with is AT insurers going back and readjusting the scope of their coverage and tweaking it in order to provide further coverage for them, such that ultimately one's going to have a very limited time frame, even if these applications could succeed, in bringing them against the AT insurers themselves. But I think it does ultimately then lead into the other question, doesn't it, in terms of is AT insurance ultimately something that's going to survive in these circumstances? And what do you think about that, Andrew?
Well, AT insurance was sort of left hanging after the Jackson reforms because, you know, it was still routinely taken out. But of course, it often functioned as reinsurance for a disbursements liability on the part of the claimant solicitors. But in circumstances where it doesn't actually provide any protection for the claimant's recovery of damages, then the question is, well, is it really worth having to that limited extent? And of course, that in turn begs the question, if people do take it out, is this is the client properly advised of the cost benefit analysis of the insurance set against the premium which would fall to be deducted from their damages or settlement? So I think it raises difficult problems, but I agree with you, Erica, in the sense that if those applications start to be made, it may be that defendants will have a degree of success against them, but is it sustainable in the long term if, for example, ATE insurers are caught short in having priced the policies on the basis they won't have to pay out, save in very limited circumstances, but then suddenly finding that because of the QOCS problems, defendants are now starting to go directly against them?
Yes, absolutely. I'm just again looking through these questions.
We're getting a lot of them, aren't we now?
We are.
It's like everybody's suddenly finished their monster munch and jumping into the debate.
They're quite difficult to try and group together, actually, is something that I found. One of the points was, in fairness, and I think this is a fair point, is can we go through the three remaining points, please, Erica? So I suspect that's something we've covered. Two of them, in fairness. So we've covered the issue in respect of detailed assessments and whether that is likely to be caught by QOCS, because it seems to me, I suppose, just touching again on that and expanding on that, certainly in my experience, it's never been an area where questions of QOCS have ever cropped up. Query whether that is as a result of the Myatt 2 argument, and everybody just accepts that in those circumstances, because the beneficiary to in reality, the beneficiary of cost proceedings is the claimant solicitor. Although Andrew's point is absolutely correct, and it's one that's obviously which is routinely lost amongst the ether, which is that these are the claimant's costs, they're not the claimant solicitor's costs. But practically, well, that does seem to get overlooked in most circumstances. But this is again where an area where defendants, in my experience, haven't been raising the points, or claimants haven't been raising the points at all. Now, this may be because of a number of issues. It may be because of the vast majority of matters which proceed by way of detailed assessment are claims which have settled by one mechanism or another. So it automatically brings us back to the query over the Part 36 point, or whether we're directly in Cartwright territory and we're on a Tomlin order. Though I think query in these circumstances, those cases, of course, where there has been an approval of damages. So thinking about high value clinical negligence claims, where you do have an order for damages from the court, but then of course you're going to be in an area where you've got a substantial level of damages, so the ceiling height is going to be significantly above, in all likelihood, the level of costs which the defendant would be seeking in the event that they succeeded on any detailed assessment. But arguments perhaps where fixed costs are present may be more of a fertile ground for claimants to look at, because what they do have is that imbalance between damages and cost which is required. So they have that limitation of damages, but they perhaps would end up with a higher level of detailed assessment costs in the event that a claimant lost an argument of fixed costs against a defendant. So it may be fertile ground for claimants to consider it in those circumstances. What do you think, Andrew?
I think it's all pointing towards one way, Erica, which is that in terms of the effect of Hoe and Adelican for defendants generally, by and large, they're knackered in terms of the approach that they can take. Yeah. Because I can see from some of the questions, and I'm not going to identify who put them, it hasn't sunk in yet just how revolutionary this decision is, because in effect, if a Part 36 offer is accepted out of time, even if there's a cost order in the defendant's favour, even if there are a string of interlocutory cost orders up to that point, if there's no order for damages and interest within 44.14, then the defendant's going to have to swallow those costs. And I think the problem that flows from that, perhaps we'll deal with this a bit later on, is the balance in the justice system and the knock-on effect for how many cases will fight set against how cases will settle.
I think that's fair, and I think your point that it's not really sunk in yet, I think is absolutely a pertinent one. It's the one that we flagged, wasn't it, right at the beginning of it. There are difficulties for defendants, and arguably that is actually bringing them back to the position where QOCS is given its full effect and its full intention, because this was the position that seemingly public policy wanted to place parties in such that defendants' costs are going to be significantly restricted, but the benefit to them is one that perhaps is again being lost in the ether, in that they no longer have to pay success fees and they're no longer having to pay significant ATE premiums, and that in reality is where the benefit is coming from, rather than, and it's a global basket over which that benefit is being received, rather than a specific and narrow benefit in simply on a case-by-case basis, where cost orders are being made in the defendant's favour. And when one balances one off against the other, defendants are still coming out with a significant saving or benefit to them that was not present before the Jackson reforms themselves.
I think that's absolutely true, Erica, because I think as human beings, we all tend to forget things very quickly indeed. And the Access to Justice Act scheme was so expensive for defendants, so unfair in its results, that it had to go. It's surprising it lasted as long as it did, with the government bleeding so much money for clinical negligence cases. And of course, the QOCS scheme whether it permits for set-off or enforcement or not, and if so, to what degree, is so much cheaper for the compensating parties that in effect it doesn't really matter if you compare the figures in 2012 and 2021. They are still saving money hand over fist compared to what the position was. But of course, people tend to look at it, and indeed as lawyers we must look at it, on the basis of the individual cases that we're advising upon. And the questions are equally valid. Do we have to lump this, or are there ways where we can circumvent it?
Absolutely. And you're right, it gets lost because of that. And it's that juxtaposition, isn't it, between our day jobs and what I suppose we're told is the effect of our day jobs by those in power, which all govern us. Just looking at some more of these questions. I think what may be useful, because I think a number of them we've touched on now and we've addressed. I'm wondering whether we can just move on, bearing in mind I think we have about 10 minutes to run, Andrew. Whether we can just run on to the final element of the practicality. So this will be the fourth aspect. So we've discussed the effect of Part 36. We've discussed the effect of detailed assessments. We've discussed the effect of applications for wasted cost against solicitors. But the final potential avenue, and in reality, I think, I personally think, and subject to what Andrew might say, but this is probably the most fertile ground for defendants, and that's disapplication of QOCS itself. And really, Lord Briggs himself opened the door to the greater applications to disapply QOCS when, in my opinion anyway, he said this at paragraph 36. He reached the conclusion that QOCS is essentially mechanical rather than discretionary, which necessitated the court to see whether the qualifying facts existed, just such as dishonesty. So if you unpack that for a moment, what he appears to be saying is actually, if the court is faced with an application to disapply QOCS, there's limited, if any, discretion for the court to exercise. And what the court's function is limited to is simply a factual inquiry to determine whether the disapplication factors are present or not. And I find that fascinating, not only because it seems to be a significant fetter, if it's correct, upon the court's function, but also I think it comes back and touches upon that which we spoke about earlier, which is whether this is obiter dicta and thus binding or not. But if one simply looks to the disapplication rules themselves, of course we have fundamental dishonesty, which has always been the popular kid on the bus. But there are other kids on the bus. And what we have under Section 2A is that there is an exclusion for proceedings which include a claim which is made for the financial benefit of a person other than the claimant, excluding, of course, care, loss of earnings, and medical expenses. And if you look at that as a test for the financial benefit, that is arguably quite a low bar which one has to factually satisfy. So think about those special damages claims, and clearly directly in the firing line is going to be credit hire claims. And actually Lord Briggs foreshadows that at paragraph 5, where it said costs incurred in the same proceedings in the pursuit of claims other than PI, and then directly gives an example of credit hire, and then concludes these may be enforced without limit. Now, if you want to look at that further, and again go back to the wording of the rule, if you look at subsection 1 in respect to fundamental dishonesty, that does not seem to have the jurisdiction that subsection 2 has, because subsection 2, which is the financial benefit for a person other than the claimant, also includes these words, only to the extent that the court considers it just. So query whether that again underlines the obiter dictum element of what Lord Briggs has said, because it does seem to me that that reference of only to the extent the court considers it just directly brings back into play the question of judicial discretion. But query whether the principle is such that one has to satisfy the factual requirement. So one has to make out as a defendant that the claim was brought for the benefit of another person, and thus the trigger is satisfied. But then when one looks to the extent of the quantum that is going to be potentially enforceable, whether that brings back in the question of an exercise of discretion. But it seems to me, whichever way one ultimately argues it, and it's ultimately decided, that credit hire claims are going to be in for a little bit of a bumpy ride, or claims which include an element of credit hire claims are going to be in for a particularly bumpy ride as a result of Hoe, particularly when those cases where one has credit hire claims which are vastly exceeding the personal injury element which is being sought. I know you've got a significant experience in credit hire claims, don't you, Andrew?
Yeah, and I think it's fair to say that the route that the liability insurers take is to seek directly a non-party costs order against the credit hire company. And that opens up a whole raft of authority and principles which have to be considered. But in effect, this is the mixed claim exception. And it's something which hasn't really come to the fore as yet. And it may certainly get more life as a result of the Hoe and Adelican point, really as a side wind, because it's not only going to be credit hire claims where it will bite. If you have, for example, actions against the police, where you may be bringing personal injury claims, but you may also be bringing claims for false imprisonment, wrongful arrest, and so on, then that is effectively a mixed claim. If you have a situation where someone's medical records are scattered over the internet so that they suffer psychiatric harm, well, that's a breach of data protection, it's a misuse of personal information, breach of confidence, breach of human rights, but it's also a personal injury claim, but it's still a mixed claim. And you can think of all these scenarios which aren't outlandish, where mixed claim exceptions could have quite a profound effect on a defendant's ability to recover costs.
Yeah, absolutely. And I certainly agree. It is an area I think that is being underused by defendants, and it's certainly something that they can go ahead and look at. I've been involved in one which was an appeal, which engaged the financial benefit exception, which was a credit hire claim. But other than that, it's certainly something that hasn't crossed my desk, nor that it's come on my radar at all, really. So I do think this is something that defendants can look at. And looking at the test, and just cross-referencing it back to your experience, Andrew, which was that third-party cost orders appear to be more the preferred route for defendants, given the difficulties which one naturally faces with those applications, and given the raft of authority which one necessarily has to go to in order to satisfy the test, one wonders whether actually on the back of Briggs's comments that it's essentially mechanical rather than discretionary, even taking into account that there is potentially, arguably, an element of discretion as a result of the wording of subsection 2 of only to the extent the court considers it just, whether that would be a much easier route for defendants to go down rather than taking the third-party cost order route.
I think it's definitely going to be explored. I'm quite sure of that, because the effect of Hoe is so sweeping and so trenchant in the rebalancing of interests against defendants and in favour of claimants. I've no doubt these points are going to be run.
Yeah, they will be. And of course, there's incentives for defendants to do so, and they've got the pockets in which to fund them. So there is always benefit to them, or a seemingly narrow benefit to them in trying to pull these out. There is authority, of course, isn't there, on this, going back to Mr. Justice Turner in Select Car Rentals, which was a credit hire claim and supports the disapplication of QOCS in these mixed claims. Though when one looks at that, he arguably decided it on a test of discretion, which again comes back to the question of whether one even look at that any further anymore. So those are the 4 areas and avenues that we thought would be useful to discuss. We now have short of 30 questions.
it's growing like topsy in terms of the points, because I think people are thinking about where this is going to go.
Which is great, and that was the purpose of the talk, wasn't it? To get people to think actually of where we are, where we could possibly go with this, where there is a potential to go with it after the judgment itself, because of the significant feta that it creates. But I think it's great that people are starting to think, and to the extent of the questions that we seem to have.
Yeah, and you're having to come up with fundamentals like what are proceedings, what is a personal injury claim, and how far can you stretch these definitions before they snap back like elastic? And I think the result, unless the Rules Committee moves swiftly, is going to be a lot of satellite litigation. I can already think of 2 cases in my diary where Hoe and Adelican is going to have a pivotal influence, and we'll have to see how those unfold. We're into the last few minutes now, Erica. Shall we start to sum up, round off, leave the audience with a few bullet points?
I think that would be sensible. Absolutely. Would you like to start?
I would. What I would say is that if you haven't read this decision, then you should, because the effect of it is that it's going to have a profound rebalancing on the position of claimants as against defendants. In effect, the claimants are going to have every incentive to pursue litigation aggressively, knowing there's a very limited downside. Defendants, you're going to have to come up with strategies to deal with that behaviour and think about how you can mitigate it. And I have no doubt whatsoever that will generate satellite litigation. What I would also say is this: if you look at it neutrally, this is going to have a profound effect for the court system, because it's definitely going to make it more likely for cases to be pushed and fought aggressively, which is likely to lead to more trials or contested hearings than would have been the case before this decision came down. So if I can leave you with the ancient curse, you certainly live in interesting times. Over to you, Erica.
Yeah, absolutely. We do live in interesting times. And just touching upon the burden on the court's already overburdened as it is. So one query is whether it's just an absolute own goal. But there we are. And practically, as we've said, there are avenues for parties to explore and for defendants to explore and for claimants to think about. But the reality is that they are limited. And one really does end up in this situation where perhaps the best option will be to look at the disapplication of QOCS under 4415 and under 4416, particularly on the back of the arguably obiter comments from Briggs, but again, query whether that is going to cause a bit of an open goal, if it's just going to lead to more satellite litigation as to whether QOCS can be disapplied or not. But ultimately, again, we absolutely are living in interesting times, and I think it just comes back to the old adage that costs is always the hot potato, isn't it? It's always there. One can't get away from it, and nobody wants to be left holding it at the end. One always wants to find somebody else to shift it on or to recover against. But because there's only limited players in that game, there's always going to be somebody who has to be left holding it. And the arguments, of course, ultimately come back to I don't want it to be me. I want it to be somebody else. And how we're going to go about that. But yes, interesting times indeed.
Okay. Well, I think we're more or less at 5 o'clock then. Thank you so much for staying with us for so long. We probably have only addressed a fraction of the questions which suddenly surged in, but it's been really good to have this opportunity. We haven't seen you, of course, so what we're going to put forward in the feedback forms, which I think you'll be getting, is whether in fact you find this benefit, this sort of remote seminar of benefit, whether you prefer face-to-face seminars, and indeed whether you'd like a mix of the two. So when you do get the forms, do let us know what you think, because we do actually read them and it is of value to us, and we hope therefore can be of value to you in the longer term. But we're now at the end, so lovely to speak, good luck and good evening.
Ed Stanfield said face-to-face seminars with drinks. I support.
Yes, well, he would, wouldn't he? There you go.
Goodbye, everybody. Thank you.
Goodbye.